They're off, go ahead, come on the top first. Thank you, may be seated.
Apologize to everyone for being late. We had some computer problems. Computers are great when they work. I just don't know how to make them work. So, Commonwealth versus Mitchell Comstock. Are you Mitchell Comstock?
Yes, sir.
Good morning. Were you born in 1967? Last four digits, social security number 8279.
Yes.
We're here on 25 CR 0013 for a pretrial conference. What's the Commonwealth have to say?
You believe we need a trial date, is that correct?
That's correct.
And I need just a little bit of time because of some documents.
What have you elected to try?
I'd like to just try it all at one time, it's all the same transaction occurs, but if I have to sever it, I would. Yes. That all on the same exact. I don't know if the defense wants to file a motion to sever or not. It's 15 counts.
What are
When you got, still another one. You've got cleaning, what they in the police first degree after you left the blue house. You got, criminal mischief first degree where you busted, Bridges' computer. You've got DUI when he was driving. You've got assault second degree when he assaulted Bridget Campbell. That's where the doctors come in. Then you've got theft of, disposition when he took Bridget Campbell's phone. You've got burglary when he went to her house unannounced and assaulted her.
is this allegedly all on one same
That
day?
it all ties in, that's what I'm saying, if they wanna sever, I think they need to file a motion. And the last 5 counts, 6 counts are PFOs. So there's 9 counts and 6 PFOs.
I'll look at filing a motion on that, Your Honor.
Well, I mean, it has an impact on how the trial might be. You want to try it this year, Mr. Stockton?
That
You
means
can't, evidently, you've got the bond problem. Is that correct?
Yes.
I can try it probably sometime in December or.
Okay, let's look at this. Do you have any out-of-state witnesses or
That's the problem I run into when somebody goes to the hospital out here. They get the ER doctor from everywhere. The last trial we had scheduled, the ER doctor, I just had to try to get him, he was from Georgia. So that's the reason I set up people full time.
Yeah. Well, we have, the 17th and 18th of November, that's a month from now.
Let's try that. I have a problem with it cleaning up again.
That works for us, Your Honor.
Let's do it on the 17th.
Three days.
Let's schedule it for 2.
Six.
How about overscheduling something on the
$8 million. I can do that.
second day, you know? Okay. Zachary Markham.
Thank you.
Thank you. Commonwealth versus Zachary Martin, 25 CR 0011, 25 CR 0060. Are you Zachary Martin? Yes, sir. Good morning. You born in 2006? Yes, sir. Last four digits, social security number 8525. Yes, sir. For a pretrial conference on 60 and a pretrial diversion revocation on 11. Mr. Hunley, do y'all have an agreement on this?
I think so.
You move to the left, sir. Is this a guilty plea?
It is a
Okay,
felony plea, Your
let
Honor.
me go down through the thing here just a little bit. A motion has been tendered that says you wish to enter a plea today. Is that correct? Yes, sir. Are you currently under the influence of drugs or alcohol? No, sir. Is this plea freely and voluntarily given? Yes, sir. Okay, are you the individual we just identified in 25 CR 0011 and 25 CR 0060? Yes, sir. Is your judgment impaired today? Is your judgment impaired today? Do you know what's going on here? Oh, yeah. Yeah. Have you discussed this matter with your attorney and are you satisfied with his advice? Yes, sir. Have you reviewed the evidence Commonwealth has against you and do you understand what you're about to plead guilty to? Yes, sir. Correct. You have certain rights, however, under the Kentucky United States Constitution. Before I can accept the plea, I must know that you understand those rights. I'm going to go down through them. At the end, I'll ask you. You have the right not to testify against yourself. No one can make you say anything right to speak trial by jury. If you're represented by counsel at your jury trial, right to confirm possible and all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to fill this matter. High court, if you lose, the right to apply the Commonwealth plea beyond reasonable doubt you're guilty of charge. You understand about entering a guilty plea today, you give up those rights. You understand that? Yes, sir. And may consider Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to prior to accept any recommendation. I will order a pre-sentence investigation report be done by probation and parole. And then after reviewing that, I decide to impose a harsher sentence. You have a right to withdraw your plea and go to trial. Okay? Yes, sir. Okay, take a look. Mr. Hunley, you're on.
Your Honor, upon a plea of guilty to assault third degree, the defendant shall receive a sentence of 3 years to serve. This 3-year sentence shall run consecutively with Clinton indictment number 25 CR 0011. The defendant is further stipulates to the revocation of Clinton indictment number 25 CR 00011 and shall receive credit for time served. Commonwealth opposes shock or probation of any kind, and the defendant agrees that any evidence be disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of Commonwealth's recommendation? Yes, sir. Are you pleading guilty because you committed the acts charged in the indictment? Yes, sir. Okay. You understand that you understand that your constitutional rights are explained to you. Yes, sir. Need to be waived, and you're waiving, right? And by entering a guilty plea, you allow the court to fix your punishment. And you understand that by entering this plea, any future conviction will be enhanced as far as your range of penalty. And you had a pretrial diversion, which is being revoked right now. That'll be a different felony. So you'll have 2 felonies. You understand that? Yes, sir. So you get persistent felony offender law, you could be charged. I don't hope you'll never get involved in another felony, but it's an enhanced penalty. You understand that? Yes, sir. Is that your signature on the order here, on the motion? Yes, sir. I'll accept the agreement order, pre-sentence investigation report, be done at probation parole. Come back here on November the 6th for sentence.
Thank you.
Probation parole be able to see. Colton and Randolph. Colton and Randolph. Commonwealth versus Colton and Randolph, 25 CR 0087. Are you Colton and Randolph? Yes, sir. Good morning. Were you born in 2006? Yes, sir. Last 4 digits, social security number 4446. I understand that you wish to enter a plea. Is that correct? Is this a felony plea?
Yes.
Motion been tendered that says you wish to enter a plea. Are you currently under the influence of drugs or alcohol? No, sir. Is this plea freely and voluntarily given? Yes, sir. Are you the same person we just identified in 25 CR 0087? Yes, sir. Is your judgment prepared today? Your judgment impaired today in any way? You know
no,
what's going on here?
yes, sir.
Have you discussed this charge with your attorney or you satisfied with those facts?
Yes,
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case?
yes, sir.
You understand that you do not have to yield plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand that. You're right not to testify against yourself. No one can make the same thing right to speed trial, the jury, right to be represented counsel in the jury trial, right to confront process. And all witnesses called to testify against you, right to produce evidence, right to call witnesses. And have process issues. You right to fill this matter higher court if you lose. And right to part of Commonwealth, we don't reasonably, I'll put you guilty charge against you. Understand that they enter the guilty plea, ready to give up all those rights.
Yes, sir.
Understand that? And I may consider the Commonwealth's recommendation, but I may apply in range of central provide law. I don't have to accept the recommendation prior to accepting your recommendation. I will await the precinct's investigation report to be done by probation pro. And then after reviewing that report, I decide not to accept the Commonwealth's recommendation and decide to impose a harsher sentence. You have the right to withdraw your plea of guilty and pursue the trial. You understand that?
Yes, sir.
Step to your left, please. Mr. Cochran, what is the Commonwealth's recommendation?
Your Honor, the defendant plead guilty of fleeing and evading police first degree, receive a sentence of 10 years. Upon a plea of assault first degree, he'll receive a sentence of 15 years. And also he will plead guilty to wanton endangerment first degree for a plea, sentence of 3 years. The 15 and 10-year sentence shall run concurrently for a total of 15 years. The 3 years shall run consecutive, making the total of the sentence 18 years. The Commonwealth opposes probation and shock probation. This sentence shall run concurrently with Pulaski Circuit Court indictment number 25 CR4. And the defendant shall receive credit for time served and pay court costs at discretion of court.
Hey, now, is that Pulaski County case, is it, there's been a plea entered on it yet?
There has been.
Okay. Is that your understanding? I want to make sure that they're running together.
Yes, sir.
Okay. Is anybody, including your attorney, offering you any benefit, or are you pleading guilty because you did commit the act charge? You are entering plea of guilty because you did commit the acts charged.
Yes, sir.
Nobody's offered you anything other than what we read.
No, sir.
Are you doing so of your own free will?
Yes, sir.
Okay, knowing your constitutional rights explained to us, it's still your desire to give up those rights and to plead guilty and not afford future punishment.
Yes, sir.
You understand that any of this plea of guilty, any future convictions can be enhanced under persistent felony offender law, PFO. You understand that? Is that your signature on there?
Yes, sir.
Yeah, I'll accept the agreement order, pre-sentence investigation report done. When is sentencing scheduled to happen in Pulaski?
I believe he's already been
Yeah,
sentenced, so
Already been
we
sentenced in
got,
Pulaski County.
we would ask the way final sentencing.
Yeah, I don't mind, but can we, with the victim impact statement, so I don't know if you have.
Yeah, we're not gonna wait, I'm not gonna do that. So, we'll look at, I'll schedule the sentencing here, for November the 6th.
Thank you.
April Russell. Commonwealth versus April Russell, 25 CR 0069. I'll get April Russell here. Good morning. You born in 1990?
Yep.
That's 4 digits, social security number 0500. You're for pretrial conference. I understand you wish to enter, please. Is that correct?
Yes.
Is this a diversion or?
It's not.
A motion been tendered says you wish to enter a felony plea. Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given?
Yes.
Are you the same person you just identified at 25 CR 0069?
Yes.
Is your judgment impaired today?
No.
Have you discussed this charge with your attorney and satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you? Feel like you're fully informed about your case?
Yes.
You have certain rights under the Kentucky United States Constitution, and except I need to know that you fully understand those rights. I'm gonna go down through them and then ask you if you understand. You're right, not to testify against yourself. No one can say anything right. So you can do like we've been presented by counsel as your trial, the right to confront. Prosecuting all witnesses to call to testify against the right to produce evidence, right to call witnesses in favor of the process issues and other opinions. You have a right to appeal this matter to higher court if you lose, and right to follow the Commonwealth if you've got a reasonable right to build a charge against you. Understand that, but you're guilty plea, they'll give out those rights. So,
Yeah.
now I may consider Commonwealth's recommendation, but I may apply any range of sentence provide law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will waive the precinct's investigation report to be done by probation and parole, and if that I do not accept the recommendation and decide to impose a harsher punishment, you have the right to withdraw your plea and trial. You understand that? Step forward, please. Mr. Hunley, what is the comments recommendation?
Your Honor, upon a plea of guilty to possession of a controlled substance, namely methamphetamine, the defendant shall receive a sentence of 2 years, probated for 5 years with the probation supervised. This 2-year sentence shall run consecutive to Wayne Circuit Indictment number 25 CR 0023. The defendant shall enter and complete a long-term treatment facility determined and scheduled through the DPA and agreed upon by the Commonwealth. The defendant shall remain incarcerated now until the morning of the bid date.
Y'all are keying the mic back up there. These mics are on all in the jury area. I know you weren't aware of that. So you step back in the jury room if you have to have something you have to talk about, okay? Proceed.
Probation and parole shall transport the defendant to the treatment facility. The defendant shall
Wait
read.
a second.
I'm sorry.
How many, there's no education in the second kick of you. I already told you once. Okay? Thank you. Go ahead.
The defendant shall receive credit for time served. She agrees to have any evidence in this case, namely the methamphetamine, destroyed in pursuant to the laws of the Commonwealth. And also, as terms of her probation, the defendant shall obtain gainful employment and do a minimum of 30 hours per week community service.
Is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes,
Doing so of your own free will?
yes,
What the constitutional rights have explained to you, is it still your desire to give up those rights, enter plead guilty and allow the court to fix your punishment as permitted by law?
yes,
You understand that by entering a plea, any future conviction can be enhanced to a persistent felony offender law. You understand that?
yes,
Is that your signature?
yes,
I'll accept the agreement, sign the order, and we'll schedule sentencing for November the 6th. Probation parole officer will be the city. Okay. Do y'all have anybody else you transported?
Yes, sir. Ellis Williams.
That's a big kill. Are you Caitlin Swift?
yes,
Okay, this is 24 CR 0017 and 25 CR 0070. Because we are running on one of them. You have a right to remain silent. You all represent the council. The grand jury of Clinton County has returned an indictment charging you with failure to signal, operating a motor vehicle under the influence of alcohol, possession of controlled substance, and first degree methamphetamine. Counselor, you acknowledge the identity of the client receiving that. Reading and arranging. Okay, and you're about to enter a plea on that one in a few minutes, so I'll let you reserve that. The motion's been tendered. It says you wish to enter a plea today. Is that correct?
yes,
Are you currently under the influence of drugs or alcohol?
No.
Is this plea freely and voluntarily given? Are you the same person we just identified in 24 CR 0017 and 25 CR 007?
yes,
Is your judgment impaired today?
no,
You discuss these matters with the attorney. Are you satisfied with his advice? Have you discussed these matters with your
Yes.
attorney, and are you satisfied with his advice?
yes,
Have you viewed the evidence Commonwealth has against you, believe you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the guilty, I need to know that you understand those rights. I'm gonna go over them and I'll ask you. You understand, okay? You have a right not to testify against yourself. No one can make you say anything, you right to speak, or I believe you right to be represented by counsel at your trial. The right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor. Right to appeal this matter to higher court if you lose, and right to private comment on a reasonable doubt that you're guilty of charge against you. Understand that by this plea today, you give up those rights. You understand that?
yes,
I may consider Commonwealth's recommendation, but I'm going to apply them sense around the law. Before accepting your recommendation, I'll wait a pre-sentence investigation report done probation and parole, and then I decide to impose a harsher sentence. You have the right to withdraw your plea. You understand that? You step to the left, y'all step to the left. step on over to the left, let Mr. Henley have the mic. Thank you. Mr. Henley, why is it comment, sir?
Your Honor, under a plea of guilty operating a motor vehicle with alcohol concentration of above 0.08, or while under the influence of alcohol or other substances, first offense, the defendant should pay a fine of $200 plus court costs. Upon a plea of guilty to possession of controlled substance first degree, namely methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years with the probation supervised. The 3-year sentence shall run consecutive with Clinton indictment number 24 CR 00017. The defendant shall enter and complete Clinton specialty court, and the defendant is presently incarcerated and shall remain incarcerated until the morning of orientation. And the defendant agrees to have the evidence in this case destroyed in compliance with the Commonwealth laws.
Move back over, let her behind the microphone. Is that your understanding of Commonwealth's recommendation?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Doing so of your own free will.
Yes.
Knowing our constitutional rights explained to you, is it still your desire to give up those rights, enter plea guilty and allow the court to fix your punishment in the range permitted by law?
Yes.
You understand that after any guilty plea to this felony, any future convictions of felony could enhance the range of penalties on a persistent felony offender. You understand that? You understand that entering this plea to DUI, any future DUIs could be enhanced under the enhanced law. You understand that?
Yes.
Is that your signature motion and offer? Well, what's the total court cost? $820, and you're gonna need some time to pay that. You're not gonna, I'm gonna have the first payment 30 days after your orientation to drug court.
Okay.
Because I'm gonna let you out for your orientation to drug court. So 30 days after that, I'm gonna set it at $50 a month. So that, you know, so it's payable. Is that your signature on the motion and offer?
Yes.
I'll order a pre-sentence investigation report scheduled with sentencing on November the 6th. So, yeah, if you might be released before then if you go through your orientation for your drug court, but if you're not, you know, either way, you'll be back there on November the 6th. Okay, understand that?
Yes.
Okay, thank you very much. Victor Barnes. Commonwealth versus Victor Barnes, 25 CR 0059 for sentencing. You are Victor Barnes?
Yes, Your Honor.
Good morning. You born in 1985?
Yes, Your Honor.
Last 4 digits, social security number 6457. You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report that was done by the probation bureau? Is it substantially correct?
Yes, Your Honor.
Counselor, is any reason someone should not be sentenced today?
No, Your Honor.
Upon plea of guilty, possession of controlled substance, methamphetamine, second offense, defendant shall receive a sentence of 3 years, probably 3 years supervised, credit for time served. Meet the other conditions. What are the court costs?
155.
155, you need some time to pay that?
I can do it within 30 days.
Well, I'll give you more time than if you want it.
I can do it.
You can pay it anytime you want to. But within 30 days, you'll pay at least $50 and $50 every 30 days after that you get paid in full, or you can pay it in advance, okay? You'll need to meet with the probation and parole officer. Okay? Christopher Braswell.
Your Honor, I'm standing for Stephen Poindexter, Your Honor. Mr. Bradford.
Commonwealth versus Christopher Braswell. Are you Christopher Braswell?
Yes, sir.
This is 25 CR 088. You born in 1999?
Yes, sir.
Last 4 digits, social security number 5736. The purpose of the arraignment, you have right to remain silent. Okay. The grand jury of Clinton County have returned an indictment charging with sexual abuse first degree 2 counts. Do you understand what those charges are?
Yes, sir.
Counselor, you acknowledge the identity requirements of the indictment, whether formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
What is your negotiation day, Mr. Stock?
October 30th at 9 a.m.
October 30th at 9 a.m. to be here for negotiation, and your next court date will be on November 6th for pretrial. Understand that? Any complaints? I'm signing a reciprocal discovery order here, requires the Commonwealth to provide your attorney with the evidence that they have to help you prepare for your defense. They're not the same conditions of bond, okay? Thank you very much. Charlotte Brown. Commonwealth versus Charlotte Brown, 25 CR 0087. Are you Charlotte Brown? Are you Charlotte Brown? Let me hear you.
Yes.
So this is a voice activated microphone. So when you speak, the camera goes on. Okay, so you have to speak up a little bit. Were you born in 1984?
Yes.
Last 4 digits, social security number 0164.
Yes.
You here for the purpose of arraignment, you have a right to remain silent, continue the appointment of public advocate to represent you. The grand jury of Clinton County has returned an indictment charging you possession of controlled substance in first degree methamphetamine. Do you understand that charge?
Yes.
Counselor, you acknowledge the guilty crime received that way formal reading, arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Ms. Brown, I'm signing a reciprocal discovery order now, requires the Commonwealth to give your attorney evidence they have to help you prepare for your defense. You're to be here at 9 a.m. on October 30th for negotiations, and the next court date will be 9 a.m. on November 6th. Both of them are conditions of bond. You understand that?
Yes.
No complaints have been made. I'll continue on the same line.
Okay, thank you.
Winter Brown. Winter Brown.
From here.
Excuse me, your line,
Yeah, she was one of my clients. She was in the hospital the last I heard.
issue a bench warrant without bond. Shirley can answer. Shirley can answer. 5 CR 0075. Are you Shirley can answer?
Yes.
Were you born in 1950?
Yeah.
Last 4 digits, social security number 5060. You here today for
Yeah.
the purpose of arraignment. You have a right to remain silent.
Huh?
The grand jury of Clinton County has returned an indictment charging you with trafficking in a controlled substance, possession of controlled substance, possession of marijuana, and possession of a legend drug. You understand that? You understand what those charges are? You understand what I just said?
Let's speak up and say yes or no.
Yeah.
You acknowledge the identity of your client, Mr. Cross, received the indictment, way formal reading, and arraignment included not guilty.
Yes, Your Honor.
Signing a reciprocal discovery order requires the Commonwealth to give your attorney all the evidence they have so you can prepare your defense. You understand that?
Hang on.
I just signed a reciprocal discovery order, which requires the Commonwealth to give your attorney the evidence they have against you so you can prepare your case. You understand that?
Yeah.
Okay. You'll be here at 9 a.m. on October the 30th for negotiation, and the next court date, November 6th, both under conditions of your bond. Mr. Cross, make sure she's steady when she walks back to the earth. She's there, okay?
Thank you, Your Honor.
Yeah. Edward Daly.
Your Honor, he's paid the restitution. I believe he still owes court costs. I'm withdrawing my motion to revoke.
How much court costs is that?
I think it was $185.
Put him on the show cause for me. Is he here?
Edward Daly. I think Bosie told him to be back for the show cause. Okay, so I guess you may do it next month.
Well, they'll be in, starting January, it'll be.
Oh, you got it.
Okay. Kimberly Elmore.
I'm
Kimberly
filling
on,
in, for Stephen Poindexter on this one as well, Your Honor.
you what?
I'm filling in for Stephen Poindexter,
Yeah.
for this arraignment.
25 CR 0073, comment Peggy versus Kimberly Elmore. You Kimberly Elmore,
Yes, sir.
good morning. You born in 1988, last
Yes.
4 digits, social security, 1247. We're here today for arraignment. Never right to name south, okay? The grand jury of Clinton County declared indictment, charged with traffic and controlled substance first degree, possession of controlled substance. Possession of controlled substance in first degree, first offense. Another count. Possession of drug paraphernalia, possession of controlled substance not in the original container. You understand those charges?
Mhm.
You, counsel, you acknowledge the identity of your client received indictment, waive formal legal arraignment, including not guilty, reserving all pre-trial motions.
Yes, Your Honor.
I'm signing reciprocal discovery orders that require the Commonwealth to present your attorney with evidence of the defense. You'll be here on October 30th for negotiations at 9 a.m. and November the 6th is your next court date. Both of those are conditions of bond. You understand that?
Right, yes,
Do you understand that?
yes.
The reason you have to speak up, it's a voice activated mic.
Oh, okay.
Camera doesn't turn on. Okay? Thank you very much. Melissa Gross. Melissa Gross. Commonwealth versus Melissa Gross, 25 CR 0079. Are you Melissa Gross?
Sir.
Good morning. Were you born in 1967? Last 4 digits, social security number 2738. You're here today for the purpose of arraignment. Are you represented by counsel? You represent a district
Yes.
court? Okay, I'll continue that. Appointment. You have a right to remain silent. The grand jury of Clinton, pay attention to me. The grand jury of Clinton County has charged you with tampering with physical evidence, possession of controlled substance first degree, and possession of drugs paraphernalia. You understand what those charges are?
Yes.
You acknowledge the ability to file a suit indictment, whether formal or even arraignment, and are pleading not guilty as though without pre-trial motion.
Yes, Your Honor.
Sign of city order here, requiring the Commonwealth to provide you the evidence they have to prepare for your defense. You'll be back here on October 30th at 9 a.m. for negotiations. And also on November 6th for your next court appearance. Both of those are conditions of your bond. You understand that?
Yes, sir.
Okay, thank you very much. Bethany Harding. Commonwealth versus Bethany Harding, 25 CR 0086. Are you Bethany Harding?
Yes, sir.
Good morning. You born in 1992?
Yes, sir.
Last 4 digits, social security number 0901.
Yes.
Your purpose of arraignment, you have a right to remain silent. So your attorney can to the grand jury of Clinton County's attorney indictment charge you with trafficking controlled substance first degree, first offense. Possession of controlled substance first degree methamphetamine. Possession of drug paraphernalia. And possession of marijuana. Do you understand those?
Yes, sir.
Mr. Cost, you acknowledge the identity of the client receiving indictment, wait formal leaving arraignment, interpleading not guilty, reserving all pretrial motions.
Yes, Your Honor.
And I'm signing a reciprocal discovery order requires the Commonwealth to provide you with information they have to help you prepare for the defense. You should be here at the Clinton County Justice Center on October 30th at 9 a.m. for negotiations, and your next court date is November 6th. Both of those are conditions in your bond, okay?
Yes, sir.
Thank you, Your Honor.
Thank you very much. Jaylee Longwell. Commonwealth versus Jaylee Longwell, 25 CR 0068. Are you Jaylee Longwell?
Yes, sir.
Good morning.
Good
Were
morning.
you born in 2005?
Yes,
Last 4 digits, social security number 4845.
yes, sir.
You're here today for the purpose of arraignment, pretrial conference.
Yes, Your
You got
Honor.
reached an agreement in this?
We have, it's a little different. It's, she would plead guilty to DUI under 21, and I've spoken with the sheriff about this case, and the remaining charges will be dismissed.
What were the names?
Possession.
Okay, a motion has been tendered today, says that you wish to enter a guilty plea. Is that correct?
Yes, sir.
Currently under the influence of drugs or alcohol.
No, sir.
Uh, This is plea freely and voluntarily given.
Yes.
Okay, you're the same person that was named in 25-0068.
Yes.
Have you had a discussion with your lawyer and are you satisfied with his advice?
Yes.
Is your judgment impaired today in any way? Do you view the evidence Commonwealth has against you? Are you fully informed about your case? You have certain rights under Kentucky, that's the United States Constitution that you have to know before I can accept a plea. Okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speak trial by jury, your right to be represented by counsel, jury trial, the right to confront and prosecute and all witnesses called to testify against you. Right to produce evidence, right to call witnesses on your behalf and that process issue to compel their attendance. You have the right to appeal this matter, hire a court if you lose. You have the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand that, but in still, you have all those rights. You understand that.
Yes, sir.
Now, may consider the Commonwealth's recommendation to make applying your range of sentence by law. This is a misdemeanor violation, so we can, if I accept the plea, we can enter a judgment today. You heard what the Commonwealth has to say. Is that what your understanding is? We'll dismiss the other charges and plead guilty to DUI.
Yes, sir.
Are you pleading guilty of the, to the DUI because you are guilty and for no other reason?
Yes.
You know, your constitutional rights explain to still your desire to give those rights. Enter guilty plea and allow the court to fix your punishment for that go off. You understand that for any guilty pleas and any future conviction of the DUI could be enhanced in the DUI. So you're not planning on getting.
21.
Well, it's under 21.
Enhanced, but it's not applied.
It is under 21 plea. I thought if they had another one while they were under 21, it could be enhanced. Is that right, Mr. Stockman? No,
I don't know that it can. That's a county attorney question. I really don't know. I'd have to
Well,
look into it.
You follow your attorney's advice on that, you know, but I'm just saying. Is that your signature on the motion?
Yes.
Accepting your, what's the fine and court cost?
What part of them are,
$200,
I think it's 200. I can get on the other one.
$820. You need some time to pay that. Okay, you start paying it within 30 days today, you pay it $60 a month. So it's paid, okay? Now take care of it. Okay,
Thank you.
be paid. Don't get into anything. Joseph McDermott. Commonwealth versus Joseph McDermott, 24 CR 0023. Are you Joseph McDermott?
Oh, yes, sir.
Good morning. Were you born in 1995?
Yes,
Last four digits, social security, 5733.
yes.
You hear that for sentencing, have you had an opportunity to look at pre-sentence investigation report done with probation parole?
Yes,
Is it substantially correct?
yes.
Is there any reason why this gentleman should not be sentenced today?
No, you're wrong.
I'm pleading guilty to theft of failure to make a liar disposition over $1,100. The defendant shall receive a sentence of 3 years of probation. And there are other conditions concerning the deal problem, correct? He shall pay restitution $1,100 through the circuit clerk's office, or $800 from the first payment due 30 days. Second period is plea, restitution subject to 5% clerk's with no contact with the victim, receive credit for time served. Is that what you're reading?
Yes.
And you made your first payment yet?
There was an issue, he said, call was like for sentencing.
Okay.
What's the court cost?
155,
Yeah, in addition to that, 165,
155.
155, you pay additional $30 a month for the court cost. Excuse me, that needs to be paid $130 a month, okay? So. You need to be with probation parole officers, yes.
Thank you.
Okay, it's 10 o'clock. I'm going to take a short pause here and go to Jackson County. Jackson County, you on the line?
Is the TV not working?
Yeah, it's.
Tell him your name.
Yes, sir.
We got well, first, Jackson Flannery. Are you Jackson Flannery?
No,
Gary Flannery?
yes, sir.
You born in 1978?
Yes, sir.
Last four digits, social security number 5544.
Yes, sir.
We have reviewed your application and you are eligible for a public defender, so I'm gonna appoint you a public defender. This is your lawyer here.
Hello, Mr. Flannery.
Hey,
You're here with the purpose of arraignment. You have a right to remain silent. Can you hear me all right?
yes, sir.
The grand jury of Clinton County has returned an indictment charging you with wanton endangerment, first degree. Another count, wanton endangerment, first degree. A third count, wanton endangerment, third degree. A fourth count, wanton endangerment, third degree. And a fifth count of wanton endangerment, fourth degree. All right, you, counselor, you acknowledge the addendum your client received an indictment, waive formal reading and arraignment, interplead not guilty.
Yes, Your Honor.
We'll have a negotiation day on October the 30th, and the next court appearance here would be on November 6th. Mr. Flannery, your attorney will make a effort to come up and meet with you in Jackson County before then. And when do you think you're gonna be up there to see Mr. Flannery?
I'm not familiar. Where's Jackson County at? How far away is it?
What difference does it make to you?
Well, I mean, it depends on whether I can fit it
On the other
in
side of London.
on the other side. Oh, well, then, yeah, I could see him. I'll see him early next week.
Yeah, he'll be over to see you. And discuss this matter with you, okay? And then if you need transportation order for negotiation or for his next year, responsible for doing that.
Yes, John.
Jackson County, thank y'all for your cooperation. Your excuse.
You're
welcome. Thank you.
Kentucky reformatory on there.
Judge, I was contacted by them, you know. Her daughter is, she said, that Mr. Martin has an outside medical appointment scheduled today and won't be available. Presumed that medical is important that he's undergoing treatment that requires him to be transported to an outside provider almost daily.
Okay, well, we'll just have to reschedule. Who's his attorney? Are you his attorney?
Yes,
Okay, you leave it, we'll reschedule that and possibly we won't wait till the next rule day. Once it becomes available, y'all get together.
She said that he should end the treatment beginning of November, so he should be back in.
Okay, that'd be fine.
Do you want to just set it for the November motion day?
Yeah, that'd be fine. Pulaski County, are you on there?
Yes, sir.
Thank you very much. Commonwealth versus Matthew Crutcher, are you Matt? No, this is Eddie Jarvis on there now. Correct. Commonwealth versus Eddie Jarvis. Mr. Jarvis, born 1947, last four digits 7422. Of course, where Mr. Jarvis, so we don't have. We can leave it on. 25 CR 0064. And pretrial conference and motion to reinstate bond.
Morning, Your Honor.
Morning, how y'all doing?
Morning, Your Honor. Brian Sargent, myself, and Brandon Strong will be entering an appearance.
I'm glad to see you. I don't know about Strong.
Well, Storm's a whole different ballgame, I understand.
I don't know about Strong. Storm is.
Judge,
Go ahead, what you got?
our motion to reinstate bond. The court's very familiar with Mr. Jarvis and his bond situation in the past, so.
Well, I want to inform you something before we go into it. This morning, of course, it's part of my responsibility to sign orders to transport, set up my staff lawyer. And we set up Zoom meetings like this today and that sort of thing. And I was informed that Mr. Jarvis might not be able to appear today because he was acting out at the jail up there, throwing food and stuff like that. So I just wanted to tell you that I been informed of that, so there's no attempt to make an ex parte communication. It's simply a procedural functional thing about his transport. You can proceed with your motion to reinstate the bond.
So what I really want to do, Your Honor, is just update you on things that have happened since then. And,
Since this morning?
well, actually, a few days ago.
Okay.
But Mr. Jarvis was found in a cell unconscious with a large gash in the back of his head. He was taken to the emergency room at Lake Cumberland Regional Hospital. 9 staples were required to close the wound. I have not done any investigation as to how that happened, whether it was another prisoner that did it, whether it was a fall, what the situation was. But his daughter was very concerned, tried to get information about his health, thought he was going to die in jail, and could not get any information. And finally, when she did get information, she's found that the prescription medication that we forgotten for Mr. Jarvis he had not been receiving that either. So that's been determined. And it's basically, he's just not a good candidate for incarceration up there, given all of his medical problems. and
He
so
might
forth.
not be a good candidate to be released either,
Well-
you know, I mean, some people aren't good candidates for anything at a particular time in their life. I mean, but let's get to the bond situation.
That's the bond situation that we would recommend is he has a camper in his daughter's home out in the county. He would be willing to do home incarceration, lockdown home incarceration at that location so that his daughter can take him to whatever medical appointments that he needs to go to and take the medication that he has been prescribed so that he can function.
When is it? Do we have a trial schedule? Y'all want to move over this way, hang behind the podium. What's your response?
Did you say the camper was?
At his daughter's house.
You couldn't get.
Yes, yeah. Out of the age, but.
Yes, just to be frank with the court and council, I don't think Mr. Jarvis is a good prisoner either. I don't think he's been a good prisoner on home incarceration because he violated his bond every time he's had it.
Yeah, I'm aware of that situation. He's not been compliant with these times that we.
I don't, and he's not amenable to entering a plea, so I don't know anything other to do than to try the case and get it over with.
Is it set for trial?
No, I'm asking for
Well,
a trial date.
let's set him a speed trial here. Okay.
Judge, we just entered, but the biggest thing is there's a couple of things that I would like an opportunity to evaluate as far as doing. So if we could have 60 days before
Give
the,
as much time as you want.
and then,
You come back here on December the 4th. And we'll be here on November the 6th. If during the intervening time, if you and your whole council, they just joining you on the case? Oh, what a impressive crew of defense counsel.
I don't know about that, but
And it would numerically anyway. So if y'all have something you want to resolve for December the 4th, you can come back on November the 6th. Or we can set a trial by agreement with the Commonwealth if you want to, if you find out that you feel like that your client's competent and other things that you want to decide by.
Thank you.
Okay, thank you very much. Mr. Jarvis, your attorneys will be up to see you. Now, we have Matthew Crutchfield up there. Matthew Crutchfield. We have Matthew Crutchfield. We're finished with Mr. Jarvis, right?
You talking about Pulaski?
Yes.
I didn't know we had anybody else.
They've got on here Jesse Pittman and Matthew Crutchfield. That's what we got on here.
Hang on just,
Jump check and see if you have them there.
I got Jesse Pittman, I can give him, I didn't know anything about it, the Crutchfield.
Matthew Crutchfield is the other one.
He's at
Jesse
County Judge.
Pittman and Matthew Crutchfield.
No one I have is Pittman, I can go get him real quick.
Okay, we'll be glad to wait for you in just a second.
Judge Crutchfield is here at Russell County.
Okay, we got Crutchfield and Russell County, so I'll move him down there. Pittman is for arraignment.
I'll furnish you certification and that,
Okay, sounds good. Judge, may I approach?
Wait a second.
Okay.
Yeah. I think.
Sure, it's my name, Rebecca.
You got the email?
Yeah, it's. It's here. There you go.
Okay, we're ready. Are you Jesse Pittman? Are you
That's
Jesse?
him.
Yeah, are you Jesse?
Yes, sir.
You were born in 1986.
Yes, sir.
Last four digits, social security number 5676.
Yes, sir.
I'm Judge David Williams. We're here in Clinton Circuit Court today. Your attorney is present. We're on 25 CR 0081 for the purpose of arraignment. You have a right to remain silent. The grand jury of Clinton County has returned an indictment charging you with strangulation in the first degree, being a persistent felony offender on the strangulation charge. Assault in the fourth degree. Those seem to be the three charges. Counselor, do you acknowledge the identity of your client, received indictment, waive formal reading, arraignment, enter plea, not guilty, preserving all pretrial motions?
Yes, Judge.
Okay, I'm signing a reciprocal discovery order, sir, that would require the Commonwealth to provide your attorney with evidence they have together. You're scheduled to be back here on October 30th at 9 a.m. for negotiation day, and your next court date's November 6th at 9 a.m. And if you need transportation officers counsel, thank you, transportation orders, you need to submit them, and we'll sign the transportation orders and try to do them like a week before.
Okay, Judge.
So we can transport. When are you gonna be able to go up and see your client?
Judge, I'll probably tomorrow or
Okay,
early next week.
Okay, your attorney's gonna be up to see Mr. Pittman very soon to go over your case, okay?
Okay, sir. I'm having problems here with my medication. I was in jail in Clinton County and I can't get them to give me my medicine and I've been going through some serious withdrawals. Is there any way you could put in an order and help me?
Well,
get my medicine?
that's kind of beyond my authority. There's an officer there with you. Officer, you've heard what he has to say here. I'm not gonna intervene in that thing. But I would appreciate if you do a review of that. I don't need a response to it right now.
April's taking care of it.
Okay, and his attorney will be up there to talk. That's not really my business, but thank you very much. Pulaski County, y'all are excused. Thank you for your cooperation.
Thank you. Have a good day, Judge.
You too.
Thank you, Judge.
Okay, we have, we have Russell County on there, and then we'll return to the docket here. Russell Taylor, Wayne. Russell County on there now?
Yes, sir.
Okay, Russell County, we have Wesley McGaw. Wesley McGaw.
Yes, sir.
Are you Wesley McGaw?
Yes, sir.
Were you born in 1988?
Yes, sir.
Last four digits of your social security number are 6977.
Yes, sir.
Your attorney is here. You have a right to remain silent. You're here with the purpose of arraignment. We're in case number 25 CR 0083. The grand jury of Clinton County has returned an indictment for criminal trespass. Also for terroristic threatening, 2 counts. Public intoxication, disorderly conduct, and resisting arrest. Do you understand what those charges are?
Yes, sir.
Okay. Counselor, you acknowledge the receipt indictment,
Yes, sir.
waive formal reading and arraignment, interplea not guilty, reserving all pre-trial motions.
He's
Yes,
got
sir.
3 other cases.
Now, we've got, the next case we got is 28 CR 0094. The grand jury of Clinton County has returned an indictment, failure to use a seatbelt, failure to signal, operating under the influence, ignition interlock device violation, resisting arrest, possession of marijuana, trafficking controlled substance, first degree, possession of drug paraphernalia, failure to surrender revoked driver's license. Do you understand what those charges are, sir?
Yes, sir.
And we have 25 CR 0095, assault, third degree, on police officers, 3 counts. We understand what those charges are.
Yes, sir.
And then we have 25 CR 0096, torture of a cat or dog. You understand what that charge is?
Yes, sir.
Okay, now, these are all arraignments. We have a negotiation day, October the 30th. And the next court date is November 6th. Both of those are conditions of this gentleman's bond. Okay,
Thank you.
your attorney will be over to see you very short, in the next few days. Next
Okay.
case, Commonwealth versus William Purdue. Pardon me, Commonwealth versus William Purdue, 25 CR 009. Are you William Purdue?
Yes, sir.
Were you born in 1971?
Yes, sir.
You need to speak up a little bit, Mr. Purdue.
Yes, sir.
For the last 4 digits, social security number 7571.
Yes, sir.
Here today for the purpose of arraignment, your attorney's here. The grand jury of Clinton County has returned an indictment charging you with possession of controlled substance, first degree, operating under the vehicle, influence, operating the vehicle under the influence, inadequate silencer, buffer, operating a motor vehicle. Is there anybody watching that door over there, Val? Is he outside? Okay. Operating a motor vehicle, expired plate, failure to notify the Grants County Department of Transportation in possession of drug paraphernalia. Counselor, you acknowledge the identity of the client receiving that.
Yes, sir.
Waive formal reading and indicated not guilty, reserving all pretrial motions. Mr. Purdue, Senator, recipient of a scaling order requires the Commonwealth provides you information about your case. You're next to be here on October 30th at 9 a.m. for negotiation. Your next court date's November 6th. Both those are conditions of your bond. Okay?
Thank you.
Yes, sir. Thank you.
We have Matthew Crutchfield there, Matthew Crutchfield. Are you Matthew Crutchfield?
Yes, Your Honor.
Good morning. We're here on an arraignment. Were you, Mr. Crutchfield, were you, born in 1997?
Yes, Your Honor.
Last 4 digits, social security number 0195. The grand jury
Yes,
of
sir.
Russell County is charged you with possession of controlled substance in the first degree methamphetamine, and possession of drug paraphernalia. You understand what those charges are?
Yes, Your Honor.
Okay. You're next to appear here on October the 30th for negotiation and November 6th for your pretrial. Sign a reciprocal discovery order. You also have a probation revocation. We'll just continue it over to the negotiation day and let you appear there on October 30th at 9 a.m. and back here on November 6th on both those charges, okay? Mary Russell. Mary Russell. Are you Mary Russell?
Yes, Your Honor.
You're on 25 CR 0067. Ms. Russell, you born in 1975.
Yes, sir.
Last four digits of social security number 6106.
Yes, sir.
You're here for a pretrial conference. It's supposed to come up, have say.
Your Honor, we'll discuss this case with the defense counsel. There's one issue on discovery that we should have an answer on pretty quick. I'd ask it to be set for the negotiation day and for November the 6th, so we can report back to the court.
You are ordered to appear to negotiation day on October 30th at 9 a.m. with your counsel. The next court date is on November 6th. Both of them are conditions of your bond. And when are you gonna be up? When are you gonna go over to see Ms. Russell?
Very shortly hereafter, Judge.
Today, tomorrow?
Tomorrow.
Okay, your attorney will be able to discuss this with you tomorrow. Russell County, do you have anybody else for us there? It looks like.
That's all, Judge.
Okay, y'all have a blessed day. You're released, okay?
Judge, that
Two,
concludes
thank you.
my business, maybe.
Absolutely, yeah.
Thank you.
Taylor County, are you on, is Taylor County on there yet? Wayne County is on. Wayne County. Wayne County. Okay, Wayne County, we have Brianna Davis for arraignment. First, Brianna Davis.
I need Kevin's to get his file through. And Brandy Scott.
Okay, Kelly Dickin, is Kelly Dickin? Are you Kelly Dickin? You need to turn that microphone on there.
Brandy.
Push the little red button that looks like an ancient microphone. Okay, there you go.
It's unmuted.
Commonwealth versus Kelly Dickin, 25 CR 0056. Are you Kelly Dickin?
Yes, sir.
Born in 1973.
Yes, sir.
Last four digits social security number 8059.
Yes, sir.
You're on a pre-trial diversion revocation. What does the Commonwealth have to say?
Your Honor, Mr. Diggin has 2 years on possession of controlled admitted to use of meth on August 18th. He was sent to Spark. He stayed there almost a month. He left on September the 15th. He did report to Mr. Payne afterwards after he was called. According to Mr. Payne, he said he didn't need the treatment, he just wanted to get out and work. And I thought, well, if he wants to work and get treatment, I thought I'd be willing to put him in the drug court program here if he wants to. If not, I'd ask for revocation.
And he's agreeable to drug court.
Okay, well, I'll enter an order referring to drug court. They'll be over to interview you pretty soon, and if you get accepted to drug court, I'll let you out at the orientation date for you to come down and be oriented. And so we'll waive the pretrial diversion revocation without making a decision on it, okay?
Thank you.
Nancy Raines. Nancy Raines. Commonwealth versus Nancy Raines, 22 CR 0067. Are you Nancy Raines?
I am.
You're here on 25 CR 0067. You were born in 2001.
Yes.
Social security number 0300.
Yes.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report?
Yeah, I have.
Is this substantially correct?
Yes, Your Honor.
Counselor, is there any reason why she should not be sentenced?
No, Your Honor.
The pretrial diversion in this, granted in this case, had been voided, is that correct? And now she's to serve 5 years.
Yes.
Okay, well, we'll enter the sentencing. Okay. Thank you very much.
Thank you.
Brandy Scott,
I'm here.
you are Brandy Scott.
Yes, sir.
This is 25 CR 0043. You born in 1994.
Yes, sir.
Last 4 digits, your social security number 1200.
Yes.
It's a probation revocation. What's the time I'll have to say?
Your Honor, she's, on September the eighth, she was supposed to report for a drug screen. She never would produce a sample. She did admit to Percocet. I think she completed short-term treatment, but then was maybe terminated from IOP. She's another one. I'm willing to put in the drug court program if she wants to go. Otherwise, I'd ask for revocation.
And she's agreeable to that.
Ms. Scott, now this, you know that you'll be under pretty strict supervision in the drug court. You understand that?
Yes, sir.
Well, I'm gonna go ahead and agree to sign an order. And you'll be interviewed if you get accepted into drug court. I'll let you out on the date that you're supposed to. Get.
I was wondering, I got a question. I'm the only child and I take care of my parents. Is there any way possible to get out sooner?
You'll need to talk to your attorney about that, and he can talk to the Commonwealth.
My position be she can get out when she's oriented, just like everybody else.
Yeah, you're gonna have an orientation, you can get out there, and Commonwealth's gonna impose the early release, okay?
Okay, and when's the orientation or will I find her?
Thank you very much.
Thank you.
Brianna Davis. You are Brianna Davis.
Yes, sir.
You're from 25 CR 0085. Miss Davis, were you born in 1993?
Yes, sir.
Last 4 digits of your social security number are what?
6360.
You have a right to remain silent here for arraignment. The grand jury of Clinton County has returned an indictment charging you with tampering with physical evidence, possession of controlled substance, in first degree, and possession of drug. Counsel, you acknowledge the client received indictment.
Yes, Your Honor.
Waive formal reading and arraignment here, please not guilty, relearning all pretrial motions.
Yes, Your Honor.
Got to sign a reciprocal discovery order. Here, requiring the Commonwealth to present you with all the evidence to help prepare for the defense. You shall be transported to here in Clinton County on October 30th for negotiations, and November 6th is your next court date, both of the conditions of your bond, okay? Your attorney will be able to talk to you. Now, Wayne County, y'all have anybody else listed for, to see us today, or is that it for?
No, sir, that'll be it.
No, y'all are released. Thank you for your cooperation.
You're welcome, sir.
Taylor County on there yet?
What they say,
I'm working.
Yeah, he's working. He said he's working on Taylor. Okay. Okay, let's go back to in court here. Jenna Nicholas. Commonwealth versus Jana Nicholas, 25 CR 0092. Are you Janet Nicholas? Born in 1987. Last 4 digits of social security number 2949.
Yes,
You're here today for the purpose of arraignment with your attorney, you have a right to remain silent. The grand jury of Clinton County has returned the indictment. Charged you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia, failure to signal, and possession of controlled substance, first degree. You understand what the charges are?
yes, sir.
Counsel, you acknowledge the identity of the client received indictment, way formal reading and arraignment, and pleading not guilty, reserving all pre-trial motions.
Yes, Your Honor.
You're to be back here on October the 30th, 9 a.m. for negotiation, and your next court date's November 6th, okay? Thank you very much. Nicholas Purdue. Commonwealth versus Nicholas Purdue, 25 CR 0061. Are you Nicholas Purdue?
Yes, sir.
Good morning.
Morning.
You born in 1992?
Yes, sir.
Last 4 digits, social security number 7862.
Yep.
We're here on a pre-trial conference. You have a plea.
Yes, Your Honor.
What kind of plea?
It's a misdemeanor plea.
Motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Plea freely and voluntarily given.
Do what?
Plea freely and voluntarily given.
Yeah.
You're the same person that we just identified in 25 CR 0092. No, 25 CR 0061.
Yes, sir.
Okay. Is your judgment impaired today?
No.
Have you had time to discuss this matter with your attorney? Are you satisfied with his advice?
Yes.
Did you fully informed about the case?
Yes.
You understand you do not have to enter a guilty plea today. You have certain rights under the Kentucky United States Constitution. Before I accept the plea, I need to know that you understand it. You have a right not to testify against you, but no one can say no one can make you say anything. The right to speak out of the jury, right to be represented by counsel of the jury, trial, right to confront counsel, and all witnesses call testify against you. Right to produce evidence, right to call witnesses in favor, right to appeal, right to hire court to ruse, right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty and charged against you, understand it, and when you're guilty plea today, you will uphold your rights, you understand that?
Yes.
And we consider the Commonwealth's recommendation, but I may claim range of sentence provided by law, I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait to pre-sentence invest, no, there's no pre-sentence, misdemeanor plea. In the event I do not accept the Commonwealth's recommendation and decide to impose a sentence, you have the right to draw your guilty plea, proceed to trial, you understand that? Stick your lip just a little bit, Mr.
Your Honor, upon a plea of driving on a suspended license, defendant shall pay a $50 fine and cost. Upon a plea of guilty of resisting arrest, defendant receive a sentence of 12 months, probated for 2 years with the probation supervised, and a $200 fine and cost when it's not probated. Upon plea of guilty to failure of a non-owner's operator to maintain insurance, defendant shall pay a fine of $250 and cost.
Keep your hands out of your pocket. Okay. Is that the offer that they made to you?
Yes, sir.
Are you pleading guilty because you didn't commit the acts charged in the indictment?
Yes.
You do so your own free will?
Yes.
When the constitutional rights explained to you is still your desire to give up those rights. And plead guilty and allow the court to fix your punishment remains to prove the law.
Yes.
You understand the intervening, is that your signature on the motion? Now,
Yeah.
before I address that, what do you think bringing a knife into the court? Is that a
Well-
knife? Is that a knife there?
I went through the scanner.
I didn't ask you if you went through the scanner. I'm asking you, you went through the scanner and you knew what was in your pocket and you brought a knife in this court.
I left it in the thing and he said, put Put your stuff in your pocket, put something in.
Okay. Well, that doesn't need to happen.
I apologize,
It's
it won't happen
okay.
again.
It's okay. I accept your explanation. Okay. I accept the agreement, sign the order. And what's the total court cost?
$500 fine, and we draw $140.
And you understand that the DUI is enhanceable. If you ever have another DUI, it can get worse for you. You understand that?
Yes, sir.
What's the total?
$1,140.
Need some time to pay that.
Yeah.
You pay $75 a month, first payment being 30 days each day. Okay?
Okay.
You got all these DUI paperwork in?
I don't think he had a DUI, just the driving unsuspended is one.
Thought it was a DUI. Okay, well, forget what I said about the DUI. Why is it that much then?
Well, then, it's $655.
So you done made $400 there in 30
I
seconds.
appreciate that, I appreciate that.
Okay, you pay $75 a month, starting 30 days from today. Okay?
Hey, thank you.
Okay. Stephanie Prater is acting owner.
It's not what they put her in CIC.
Michelle Shelton. Pamela versus Michelle Shelton, 25 CR 0091 for arraignment. Are you Michelle Shelton?
Yes, sir.
Born in 1990,
1980.
1980, excuse me, last four digits of social security 0659.
Yes, sir.
Okay. You have a right to remain silent. You're here for arraignment. The grand jury of Clinton County returned to indictment charging you 2 counts of wanton endangerment, failure to maintain insurance, operating under the influence, possession of controlled substance, first degree. Possession of drug and health, and now you got and driving on suspended operator's license. Counselor, you acknowledge the identity of the client received indictment, wait formal reading, arraignment, and include not guilty, reserving all pretrial motion.
Yes, sir.
Send a reciprocal discovery order that requires the Commonwealth to give your attorney evidence to be prepared in case. You'll be back here on October 30th for negotiation date, and the next court date is on November 6th. Okay?
Yes, Sean.
Thank you very much. Mitchell Thrasher. Commonwealth versus Mitchell Thrasher. 25 CR 0080. Are you Mitchell Thrasher?
Yes, sir.
Good morning. You were born in 1964.
Yes, sir.
That's 4 digits, social security number 3055. You're here today for the purpose of arraignment. You have a right to remain silent. Wait your attorney's with you. Grand jury of Clinton County's attorney indictment charging you possession of controlled substance, first degree, and possession of building permit. You know what those charges are? Counselor, you acknowledge the identity of client received indictment, wait formal reading, arraignment, interplea not guilty, reserving all pretrial motions.
Yes, Your Honor.
You will be back here on October 30th for negotiation, and the next court date is November the 6th, both of them in condition to you. Send a reciprocal discovery order on you two. Provide your attorney with evidence of the very case. Okay, is there anyone else here in the courtroom? Dusty Gladwell. I know it's Dusty Gladwell. This is 25 CR 0065. Are you Dusty Gladwell? You born in 1989.
Yes, sir.
Last 4 digits of your social security number 4526.
Yes, sir.
You're here for the purpose of arraignment. Represented by counsel, the grand jury at Clinton County Attorney indictment charging you possession of a handgun by convicted felon. Possession of controlled substance. Possession of drug paraphernalia. And receiving stolen property. Mr. Cross, you acknowledge the identity client received indictment with a formal reading and pleaded not guilty.
Yes, Your Honor.
Reserving all plea trial motion. What, Mr. Stockton, what's this handgun charge here?
I'll have to look at the files. We'll give you just a moment.
Your Honor, what found during a search of his property.
I think that's correct. Just let me verify. There was a search warrant executed on the property and that's when it was found.
10,000 gauge. Okay, we'll, you'll need to be scheduled to come here on October the 30th at 9 a.m. for negotiation. And November the 6th at 9 a.m. Both those are conditions you buy. Now, Mr. Bible, I take these weapons charges, you don't need to be around any weapons. No honey guns, no handguns, no guns at all. You understand that? Okay. Okay,
Thank you.
that's it. Does that take care of everybody that's in the courtroom? And then let's go to the Clinton County Jail. You ever hear anything from Taylor County?
Judge, they said that
That
they're
was
trying
our-
to get on.
No, I can't. I'm sorry.
They said they're trying to get on. They had another court going on right now and
Okay, well, we'll just tell them we're here. And whenever they get on, we can hear them meet and text them.
yeah.
Good morning, Your Honor. The Spanish interpreter is on the line.
Okay, let's do Tamara Stamp. Oh, yeah, Antonio Velasquez, excuse me.
Get him right
Have the interpreter present, yeah, Mr. Velasquez. Okay, Madam Interpreter, you raise your right hand. Solemnly swear affirm that you may accept it. Report to the Commonwealth Attorney, Commonwealth of Kentucky as an interpreter, do you truly and faithfully interpret the proceedings and have before you. Do you do that?
I do.
Commonwealth of Kentucky versus Antonio Vasquez,
Estado de Kentucky contra San Antonio Vázquez,
18 CR 0006.
18 CR 0006.
Mr. Vasquez, you're here for the purpose of sentencing. Have you seen the pre-sentence investigation report done by probation parole?
Señor Velázquez, usted está aquí para la sentencia. ¿Ha visto este informe precondenatorio que prepararon en la Oficina de Libertad Vigilada?
Sí.
Yes.
Counselor, is everything in there substantially correct?
Yes, Your Honor.
Is there any?
Abogado,
Go ahead.
¿todo lo que dice el informe es fidedigno, licenciado? Sí.
Is there any reason why this gentleman should not be sentenced?
No, Your Honor.
¿Hay alguna razón por la que no se le deba sentenciar hoy a este señor? No, señoría.
Then upon a plea of guilty to incest, a class B felony, the defendant shall receive a sentence of 10 years to serve.
Con la declaración de culpabilidad por incesto, un delito serio de clase B, el acusado recibirá sentencia de 2 años.
Considering the length of the sentence, I'll waive court costs.
Thank you.
Considerando la duración de la sentencia, renuncio a los costos.
This is the duty to register form. I went over that as well with
What is
him.
it?
The duty to register for a sex offender.
Sex offender duty version. He went over it with him at the jail. I think he signed it.
Okay, we have to let this thing be interpreted.
Oh, my goodness.
Thank you, Your
Now,
Honor.
the defendant's attorney is presenting to me a duty to register as a sex offender.
El abogado de la defensa me ha presentado un documento que se llama obligación de registrarse como agresor sexual.
Is this your signature on there, sir?
Esa firma en el documento es la suya, señor.
Sí.
Yes,
I will sign it as being done in open court.
la firmé y que conste que se ha hecho en plena sala. Yes.
Is there anything else I need to do?
¿Hay algo más? ¿Hay algo más que tenga que hacer?
That finishes the case. Thank you very much, Madam Interpreter. You are excused.
Thank you, Your Honor. Eso concluye el caso, señor Velázquez. Gracias.
¿Todo?
Would that be all?
Yes, that's all.
Sí, señor, eso es todo. Gracias.
Gracias.
Thank you.
Holden absent.
Oh.
Are you Holden absent?
Yes, sir.
This is 25 CR 0069. You're here today for sentencing. Were you born in 1998?
Yes, Your Honor.
Last four digits of your social security number are 4431.
Yes, sir.
Yeah.
No. You see them. Good job. Mr. Absent, have you had an opportunity to look at the pre-sentence investigation report on the probation parole?
Yes, sir.
Counsel, was it substantially correct?
Yes, Your Honor.
Is there any reason this gentleman should not be sentenced?
No, Your Honor.
I'm pleaded guilty of assault 33 counts. The defendant shall receive a sentence of 5 years on each count and then consecutive for 2 years. Serve 180 days in jail, balance probated for 5 years. Shall the anger management and counseling and do everything the commission says. What are the court costs? Has he served his 180 days yet?
He has not, Your Honor.
Okay, well, as soon as you get out, you 101.
55.
Court costs $150. You pay $50 a month starting 30 days after your release, okay?
Yes, sir.
Okay, thank you very much.
Thank you, Your Honor.
Michael Ash. For sentence.
I gotta run back here and get him, Your Honor. I'll be right back.
Okay.
Hey, Melissa. Melissa, will you let them know that I resent that link?
Where did she go? Yeah, go ahead and turn her. Violated here. Have to write it down.
Here, Your Honor.
Okay, are you Michael Ash?
Yes, sir.
Okay, you're here today for sentencing in 25 CR 0037. Mr. Ash, you born in 1960.
Yes, sir.
Last four digits is social security number 0684.
Yes.
Okay, have you had an opportunity to look at pre-sentence investigation report here done by probation and parole?
I'm sorry, Your Honor. I didn't hear you.
Have you had an opportunity to look at this pretrial, this pre-sentence investigation report done by probation and parole?
Yes, Your Honor.
Okay, Counselor, is it substantially correct?
Yes, Your Honor.
Any reason this gentleman should not be sentenced?
No, Your Honor.
Pretrial diversion was voided on September 11th, 2025. Therefore, this gentleman, Mr. Ash, is sentenced to 3 years. Okay, thank you very much. Christopher Burkett.
Just get him out, Hunter, just give you, that's the second hitting.
Are you Christopher Burkett?
Yes, Your Honor.
This is 25 CR 0077. Were you born in 1962? Were you born in 1962?
Yes, sir.
Last 4 digits of social security number 9537.
Yes, sir.
You're here for the purpose of arraignment. You have a right to remain silent. Your attorney is here. The grand jury of Clinton County Attorney indictment charging you with failure to comply with sex offender registry. Do you understand what that charge is?
Yes.
Sign a reciprocal discovery order. Probably the Commonwealth to give you all the evidence they have concerning your case. You're required to be back here in Clinton County on October 30th at 9 a.m. for negotiation, and your next court date is November 6th at 9 a.m. Counselor, we'll make sure you do transportation order.
Yes, Your Honor.
Your attorney will be able to see you in the next couple of days, okay? Thank you very much. Billy Davis next.
Getting him right now, Your Honor.
Commonwealth versus Billy Davis, 25 CR 0071. Are you Billy Davis?
Yes, sir.
Good morning. Were you born in 1970?
Yes, sir.
Last 4 digits, social security number 1524.
Yes.
I'm here for arraignment. The right to remain silent. Grand jury of Clinton County has returned an indictment charging you with expired registration plates, failure to maintain insurance, and possession of controlled substance, as well as possession of drug paraphernalia. We understand those charges. Counsel, you acknowledge the guilty and client received indictment. Wait for reading and arraignment and pleaded not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Sign a reciprocal discovery order require the Commonwealth to provide your attorney all the evidence they have so you can prepare for your defense. Y'all are keying, y'all are picking up on the mic. Hey, you be here on the 30th for negotiation at 9 a.m. and November 6th for the next court date, both of them conditions of bond. Austin, your attorney will be over to see you, Mr. Davis.
Thank you.
Austin Edwards.
Your Honor, would you want to pass Mr. Edwards a few minutes so we can get a plea document signed? He does need to be arraigned on a new charge, and we're going to have that resolved.
Yeah, that's so.
Thank you.
Going to come back to your case, Mr. Edwards. Dawson Jarvis. Sentencing. Are you Dawson Jarvis?
Yeah.
We're on 25 CR 009, 25 CR 0016. Mr. Jarvis, you were born in 2001.
Yeah.
Last 4 digits, social security number 7215.
Yeah.
Here for the purpose of sentencing. Okay. First one is on 29 CR 009. There's a pretrial diversion that was revoked, voided on September 11th, 2025. And then there was 25 CR 0016. Which was revoked. On September 11th. Voided 2025. And you had an opportunity to look at these pre-sentence investigation reports done by probation and parole. So, young man, have you looked at these? Have they shown you these pre-sentence investigation reports?
Yeah.
Okay. Counsel, are they substantially correct?
Yes, Your Honor.
Commonwealth recommended 2.5 years on each one of these run consecutive, which total 5 years. That's what we'll do. Enter judgment is 5 years. Okay?
Thank you.
For the court cost. $155, and when you get out, you start paying $50 a month on the court costs 30 days after you release. Okay?
Okay.
Thank you. Wendell Shelton. Wendell Shelton.
Yes.
Are you Wendell Shelton?
Yes.
Good morning. You're on 25 CR 0093 for arraignment. Mr. Shelton, you born in 1978.
Yes.
Last 4 digits of social security number 2766.
Yes.
You have a right to remain silent. The grand jury of Clinton County charged you with sexual abuse in first degree. You understand what that charge is? I'm not asking if you did or not, but you understand what the charge is?
Yes.
Okay. You shall acknowledge the identity of your client, single out, wait for more hearing, and if you're not guilty, is there an pre-trial motion?
Yes, Your Honor.
We will schedule a negotiation day on the 30th this month and next court date on November 6th. Your attorney will be over to see you in a day or two. Thank you. Steve Stearns, your sentence. Commonwealth versus Steve Stearns, 25 CR 0063. Are you Steve Stearns?
Sir.
Were you born in 1987?
Yes, sir.
Okay, y'all gonna have to hold it down. You're keying the mic. Somebody's keying the mic. Last 4 digits, social security number 7231.
Yes, sir.
We're here for the purpose of sentencing. If you had an opportunity to look at pre-sentence investigation report number probation parole.
Yes, sir.
Substantially correct, counsel?
Yes, Your Honor.
Any reason this gentleman should not be sentenced?
No, Your Honor.
On plea of guilty to criminal possession of a destructive body trap device. Booby is what it should be. It's not Bobby. We won't blame this one on Bobby. It's Booby.
Yes.
The defendant shall receive a sentence of 5 years, probated for 5 years.
How long would it?
What are the court costs? Court costs are $155. Can you pay that today or need some time?
I need time.
You pay $50 a month, first payment starting. Variation today. Now, is he to be released today?
Yes, Your Honor.
Okay, okay. When can you meet with probation parole?
I'll be down to see him as soon as court is over.
Okay, the probation parole officer will be over to see you as soon as court's over. You're not to be released till then, okay? And he'll go over the stuff. So you need to get ready for somebody to come and get you, all right?
Yes, sir.
Okay. Lucian Stevens. Lucian Stevens. Are you Lucian Stevens?
Yes, sir.
You born in 1996?
Yes, sir.
Last 4 digits, social security number 5171.
Yes.
We're here on 23 CR 0032 on a pretrial diversion revocation. What does the Commonwealth have to say?
Your Honor, I received a violation report from probation parole. And the main violation was Mr. Stevens was living in a camper on the property of a convicted felon. He made arrangements to live at 84 Crosscut Drive here in Albany and then moved to Albany Manor Apartments. Now, that's satisfactory to the Commonwealth, but it is the court. We submitted the order in lieu of revocation, so.
Recite that again. Can you hear us there, Mr. Stevens?
Yes.
So you agree to move when you get out?
Do what?
You agree to move your residence when you get out?
Yes.
Okay, well, I'll let you out today and ask that probation parole check on him sometime in the next couple of days to see where he's supposed to.
And he'll be back on active supervision.
You'll be back on active supervision, so you'll need to contact the probation parole office to make arrangements with him, okay?
I'll be to the jail to see him as soon as court is over.
Okay, don't release Mr. Stevens until he talks to probation parole right after court.
Yes, sir.
Thank you.
David Sullivan. Mr. Cross. Where is Mr. Cross?
He's at the jail. There he is.
There's Mr. Cross.
He's in jail.
23 CR 0044.
I'd like to keep him.
Right there, Mr. Yeah. Commonwealth Attorney said you were right in your element there, Mr. Cross. This is a motion for bond modification. What do you have to say, Mr. Cross?
Your Honor, we've got an agreed order with the Commonwealth.
And I want to hear what you have to say about it.
Your Honor, Mr. Sullivan's never avoided prosecution in this case. He went home to Smithville, Tennessee, and was actually called once by the police officers there and says, "We have a warrant on you. We'll come pick you up." He said, "Fine." And then they called back and said, "No, the paperwork wasn't in order. They couldn't serve it." But he's never avoided prosecution. He has some issues in the jail. He's got some health issues that we're going to help him pursue. He lives with his mother.
Mr. Stockton, what are the charges?
Yes. It's traffic violations along with wanton endangering first and fleeing evading first degree was his charges.
Basically, Your Honor, the accusations, he ran through a construction site.
Yes, because there's a substantial amount of restitution, about $7,000 restitution.
What was damaged?
It was, I think it was the police car.
There's the reason why you didn't sign the great orders, because he was indicted on September 26th, 2023.
Yeah, we had an agreement, I thought, at one time.
And Judge DePon, and it was placed in CIC November of that year. And then wasn't started with the environmental field.
This was old enough case, this is former Jeff Vincent's case. This was old enough that Sheriff Jeff Vincent was time.
So you had a plea agreement, I turned it down?
Your Honor,
What? Where's he been for the last 2 years?
I guess he's been innocent.
That concerns me.
Your Honor, apparently he didn't have a court date. He's been in jail now 3 months. He's turned down the plea agreement since he's been in jail. There's a KCPC order on him. And,
One thing that concerns me is if he is let out on bond, he's gonna have to have adequate communication because he's supposed to be seen by KCPC. He's
Well,
gonna have to be video, there'd have to be a video examination. So.
his mother may be courtroom, Jesse.
Yeah, I know, I'm just saying, if he's let out, I just wanna make sure she knows that she'll have to, when she's contacted, he'll have to do that.
Yeah.
Yeah.
He's with-
I ain't fussing, I'm just saying it's gotta be done.
If I know what to do, it would be done.
I'm taking a chance on him too. I've got a bond assignment. If it's forfeited, I lose that.
Well, not much change on it. You know, the money's there, it's not going anywhere, and I don't think he is either. I
No,
mean,
he's-
I just,
He's gonna
the
show.
fact that he's been gone this time period and the damage, you know, I don't know, fleeing and looting, going through a site like that. And then we have a competency evaluation, is that what this is?
Going to be an outpatient evaluation at some point in time, Your Honor.
Well,
That was the problem, I think he was set for the plea, and somebody moved for a competency evaluation. And that was in August of 23,
what was the plea agreement?
August of 25. The plea agreement was gonna be the version he was gonna have. He was gonna plead to the DUI, he was gonna plead to the one endangerment, he was gonna receive a sentence of 5 years. He's gonna be diverted and supervised, and he was gonna pay back the $7,721, that started at $128 now.
Is your client willing to go along with that previous agreement that he had, or?
Your Honor, this is my first day of hearing from Mr. Sullivan. Mr. Rutherford represented him.
Well, what I'm gonna do is I'm gonna let you talk to him and determine this competency situation. I am not comfortable releasing anyone from bond that has a competency issue with these kind of charges and that sort of, I'm just not comfortable with that. So you take a look at him, and if he wants to have a competency review, then we'll do that, and we can do it by video, it'll be a glance. If after you talk to him, you think there's not a competency issue, if the Commonwealth is willing to go along with the previously offered plea, we can hear it in another county. Okay?
Your Honor, the problem I have with that is I'm confident Mr. Sullivan's competent to stand trial, but as far as his culpability at the time of this, in talking to he and his mother and in looking at medicals that we've seen, there was an issue at the time that this occurred, and I can't just come in and waive that and say that's a non-issue.
I'm not asking you to, I'm not asking you to waive anything today, I'm asking you to investigate the situation. Look at it, you say you're not familiar with it, today's the first time you've represented it. I've looked in the record and there's some indication because of his privacy. I will not talk about the mental issues online with specificity, but I have access to it now. I'm just not willing to release somebody that I don't know any more about this, and that there's now it's competency. Now you're talking about whether or not he was culpable at the time. That might involve the full range of issues that I need to be aware of before he gets out on bond. So I'm sure, Mr. Sir, that you have competent counsel now, and he will review these sort of things and be in contact with the Commonwealth, and we can set a hearing on this and not wait to the next hearing day here. Okay, thank you very much.
Your Honor, can we go to Dr. Sparks on the Marist tank?
Yeah.
This case, that was,
So, okay, we're finished with Mr. Sullivan. We just have one more case, it looks like, in the Clinton County Jail. It'll be very brief. Robert Wright.
Yes, Your Honor.
Are you Robert Wright?
Yes, Your Honor.
Okay, are you born in 1981?
Yes, sir.
We're here on 20 CR 0070 for probate, for revocation and arraignment in 25 CR 0072. You represented by counsel, you have the right to remain silent. The grand jury of Clinton County has returned an indictment charging you in possession of controlled substance in first degree first offense. In possession of drug paraphernalia. You understand what those charges are?
Yes, Your Honor.
Counselor acknowledging the identity of your client, receiving indictment away formal reading and the plead not guilty to all pre-trial motions.
Yes, Your Honor.
This gentleman should be here on October 30th at 9 a.m. For negotiation, and back here on November 6th for his next court appearance. Both of them conditions of bond. I'm signing a reciprocal discovery order, sir, that requires the Commonwealth to give you all the information they have. And then we'll go to Taylor County for the last one. Taylor County, your attorney will be able to see. Taylor County. Taylor County, you turn your camera off, thank you. Are you Corey Baird?
Bard, yes, sir.
Bard, excuse me, Mr. Bard. This is 24 CR 0028, 24 CR 0039. Mr. Bard, were you born in 1993?
Yes, sir.
Last 4 digits of social security number 0642.
0642?
0642, yeah. We're on probation revocations on 24 0028 and 0039. What does the Commonwealth have to say? You move over.
Your Honor, he has a 10 years sentence.
This what?
He had a 10-year sentence, and my understanding is he's gonna stipulate, he stipulated in Wayne County the other day.
Okay. Okay, is that correct, sir, Mr. Bard?
Yes, sir.
Stipulating? Yeah, okay, well, I'll go ahead and impose, revoke revoke. Let's see. Revoke the probation in 24 CR 0028 and 0039. Okay, thanks very much.
All right, thank you.
Okay, then we have all the, does that conclude everything we have?
Your Honor, we need to call Nicholas Purdue up, but I'd like to take the
Thank you.
IRS stamp.
Let me have about a 2-minute break here. Let's go off just for a second before I break. Back on the record, we call Monroe Circuit Court shall come to order, meeting by agreement in Clinton County. The case is 25 CR 0010, Commonwealth of Kentucky versus Tamara Stain. Okay,
Do we have Barron County Jail on? I see them on the
in
screen.
Marion County, you turn your camera on. Are you Tamara Stamper?
Yes.
You born in 1985?
Yes.
Last four digits, social security number 1699.
Yeah.
Okay.
Yeah, this is my motion for treatment, Your Honor, to restore competency. And I have Dr. Sparks here to testify.
Okay, Dr. Spark, can you raise your right hand? Swear the testimony you're about to give us the truth, whole truth, and nothing but the truth.
I do.
Candace, you turn your camera off, and I'm gonna turn my camera off. Maybe we can get Dr. Sparks.
Whatever. He's on.
Okay.
Yeah.
Go ahead.
Dr. Sparks, did you evaluate Ms. Tamara Stamper as regards competency to stand trial?
I did.
And could you briefly describe that process?
Certainly. Prior to meeting with Ms. Stamper, I reviewed any information I had at my disposal. In this case, I had, of course, the court order. I also had police reports I could review. I also had her criminal history record. I reviewed that. Then I met with Ms. Stamper. I observed her for symptoms. I asked her about symptoms. I completed psychological testing and screening, and we talked about the alleged offenses. After meeting with her, I was able to conduct an interview of her daughter, her adult daughter. It was upon that information that I based my opinions.
Okay. And what were your opinions and findings after your review of her case?
It's my opinion that Ms. Stamper does have the capacity to appreciate the nature and consequences of the proceedings against her, but that she lacks the capacity to participate rationally in her own defense.
Okay. And based on your testing and findings, do you believe it's possible that she can be restored to where she can participate rationally in her defense?
Yes, I do.
And what kind of treatment would that entail, and what would you have to do in order to attempt to do that?
Well, I would recommend competency restoration treatment at KCPC. My understanding is locally there's not any outpatient restoration available at this time. And so at this time, the place for competency restoration treatment is KCPC. It would require a court order, 504-110, I believe, ordering restoration to competency, at which point she would be transferred to KCPC. She would retain her place on the waiting list, so she would be there sooner rather than later, we would hope.
And what period of time would be required for that competency restoration treatment?
Having worked at KCPC for between 10 and 15 years, I would say usually competency restoration occurs within 30 days. There are situations where there are some more intractable symptoms and they have requested 60 days. I've rarely seen it go over 60 days necessary for restoration. It is possible, it has happened, but usually it's 30 days. And then if not that, usually it's 60 days.
So if we enter a court order that not to exceed 60 days, you think that would be sufficient?
I do.
Okay. I have no other questions.
Do you have any questions?
Hold on, Tamara. Just a couple of questions, Your Honor.
Proceed.
Dr. Sparks, so can you guarantee that Ms. Stamper will regain competency within 60 days?
No.
So it is possible that
World peace, Mr. Sparks. Can you guarantee that can you guarantee there will be world peace?
I cannot guarantee that either, Your Honor.
No, we can't guarantee anything. Gee. You have any other questions?
just one, Your Honor. So it is possible that at the end of the 60 days that Ms. Stamper may remain incompetent.
Yes.
Okay. I have no further questions.
No reiterate.
Okay, I'll enter an order directing KCPC to do a evaluation to see if we can have restoration.
Your Your Honor, prior to entering that order, I do want to raise just one objection. Ms. Stamper has indicated to me that she does not believe that she is in need of treatment at KCPC, so we are just asking for you to not enter an order sending her there.
If you have any testimony other than her opinion, if her opinion, according to the professional, mental health professional here, her opinion on that's not to be considered very closely. That she has this problem, and I'm going to enter an order, try to get her to compensate, move this case. Okay. Thank you very much, Doctor. You can be released. Thank you for your participation.
Thank you, Your Honor. Thank you, everyone.
That concludes the Monroe Circuit Court.
Fourth course. First. Your Honor, on Nicholas Purdue, he previously entered a misdemeanor plea. That was based on me reviewing his records, that he had no prior drug offense or alcohol convictions. He also adamantly maintained to his counsel, which was conveyed to me, that he doesn't have a drug problem. He doesn't want to enter no drug plea. Well, Mr. Payne goes back there and tests him, and he's positive for marijuana, and he admitted to meth use 4 days ago. So I would like to set that plea aside based on those fraudulent representations, and he's agreeing to enter the felony plea now, is my understanding. And I don't know if the court's willing to do that or not, but I don't want to leave here today without informing the court what's happened in the Commonwealth's position.
What's he got on the shelf? What did he plead to, a year?
He's been pleading for 3.
No, what did they plead to previously?
Today, he pled to misdemeanor 12 months for supervised 2 years. But the problem is, we didn't know this. He lives in Tennessee. We can't supervise a misdemeanor in Tennessee. So either I'm going to move to revoke the misdemeanor or set it aside one.
Yeah, that's what I was saying. That's the choice.
Yes.
And Your Honor, we've come to an agreement now that he's willing to take. We just ask that we set it aside and allow this new agreement to be tendered to
Well,
the
I
court.
get an order setting aside. Where's this case appear on?
He was on that custody document today.
What's his full name?
Nicholas Purdue.
Have Mr. Purdue come around. I hadn't even signed the other order anyway.
Oh, you had to sign it, so we'll go ahead and order another plea.
Yeah. We're calling back 25 CR 0061. There's just been an explanation right before we hear that there was either some misunderstanding or misrepresentation concerning the status of Mr. Purdue, his drug use, that sort of thing. The judgment, the misdemeanor judgment had not been signed and had not been entered. So the Commonwealth was drawing that by agreement with the defendant. Will you just go over, Mr. Stockton, we've already identified Mr. Purdue, have all the information necessary on there. There's no reason to repeat that.
Your Honor, in lieu of what's happened before, he would plead guilty to driving on a suspended operator's license, pay a $50 fine and cost. He would plead guilty to resisting arrest, pay a $200 fine and cost. He would plead guilty to non-owner operator failure to maintain insurance, $250 fine and cost. He would also plead guilty to possession of controlled substance, first degree, receive a sentence of 3 years, probated for 5 years, supervised. He'll attend and obtain anger management counseling. That was in the previous plea. He'll receive credit for time served. He'll obtain and maintain gainful employment or do community service.
Okay, Mr. Purdue, you realize that by entering a plea to this, if you have another felony, you'd be subject to persistent felony offender enhancement. You understand that?
Yes, sir.
Okay. The counsel, you've informed him the difference between a misdemeanor and a felony plea. He's just acknowledged that.
Yes, sir.
What's the total cost?
$150,000.
There wasn't a DUI involved. That's when I got mixed up on the DUI previously. What did I order in place?
$75,000.
75, it'll still be in place. Probation parole officers right over there. Now, what are we gonna do here as far as till we get him, you're gonna transfer him over to Tennessee for supervision, is that correct?
Well, he won't plead till he won't be sentenced till next month.
Yeah.
Then I can try to transfer him where he don't have a Tennessee driver's license. The issue will be he'll have to stay in Kentucky until they accept his probation.
Yeah, well, I'll set the or a pre-sentence investigation report to be done probation parole. Have sentencing here on November sixth. Now, do you have a place you can stay in Kentucky till then?
My brother David's on the other part of the person I could stay with.
Well, you don't need to leave the state of Kentucky
Okay.
until
I
you come.
know he's a convicted felon, but I have no objection if he has to stay there. Okay.
What'd you say?
I have no objection if he needs to stay with Mr. Kagan. Yeah.
Okay, that'd be fine. Thank you, probation parole. Okay, that concludes the criminal docket.
Your Honor, he's got no man.
Austin Edwards.
No. No.
They said it got logged off down there at the jail, so they'll need to be reconnected.
Where's Austin Edwards?
Mr. Cross.
Oh, there he is. Yeah, there he is right there. Somebody contacted the Clinton County Jail. They have to initiate it. Anybody here know anybody at the Clinton County Jail?
Did you want to on the same link? Yes. I think Chris is following. What about Chris? We want you.
They were expecting y'all to contact him because I told them Austin would have.
She'd get him right there.
They have to do it. I can't do it.
Oh, well, they said, okay, well,
Squad there.
but they won't do it until somebody tells them to.
No, it's such. All right, be careful going on.
Okay, Clinton County Jail, you turn your camera on. I say. This kid Lavitt was here, we'd seen him down there.
He run down there at a brisk pace.
Clinton County Jail. We call a case of Commonwealth versus Austin Edwards. They're gone. Just call, let's go off the record just for a second. Call down there and have them bring Austin Edwards up here. Somebody call down there and tell them bring Austin Edwards up here.
Your Honor, while we are
Off.
waiting for the presence of Mr. Edwards, I'd like to.
What are you doing here? I don't know what you're doing. You want to be on the records that we're?
No, right here, I don't need to be.
Okay.
But we will be if you.
Who's this attorney? Cross here. Commonwealth of Kentucky versus Austin Reed. Excuse me, Austin Edwards. Commonwealth of Kentucky versus Austin Edwards, 25 CR 008. Are you Austin Edwards? Yeah. You born in 1999? Yes, sir. Last 4 digits, social security number 5883. Yes. We're going to 25 CR 008 for the purpose of arraignment. You have a right to remain silent. Grand jury Clinton County is returned into that and charged with possession of controlled substance, not the original container. Possession of controlled substance in the first degree. And then operating a motor vehicle under the influence. You understand what those charges are? Yes. Also acknowledge the identity of your indictment. Again, your client receiving that way formal and enter a plea of not guilty, reserving all pretrial motions.
Your Honor, we want to enter a plea of guilty to DUI and to possession of controlled substance first degree.
You just heard a motion. It has been made. It says you wish to enter guilty plea today. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol? No. It's please freely and voluntarily given.
Yeah.
That you're the same person that you just identified in 25 CR 008. Is that correct?
Yes, sir.
Is your judgment impaired today?
No.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yeah.
You, the evidence the Commonwealth has against you, you will be fully informed about your case.
Yeah.
You understand that you do not have to enter guilty plea today. You have certain rights under Kentucky United States Constitution or the right for me to be able to accept a plea. I need to know that you fully understand those rights, and we'll go over them with you, okay? You have a right not to testify against yourself. No one can make the same thing, right to speak, trial, or jury. I can represent the counsel to jury, but I have a right to confront, cross-examine all witnesses, call, testify against you, right to use evidence, right to probably witnesses in your favor, right to appeal this matter to a higher court if you lose. Right to file a Commonwealth and prove that reasonable doubt that you're a guilty choice. Unless you understand that by entering a guilty plea today, you give up those rights. Now, you understand that?
Yes, sir.
Okay, now I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept the recommendation prior to accepting the recommendation. I will wait to pre-sentence investigation before we then post the recommendation. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea guilty and proceed to trial. Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, he would plead guilty to operating a motor vehicle under the influence, first offense, pay a $200 fine and cost. He would also receive a sentence of 2 years, probated for 5 years on the possession of controlled substance. He would enter and complete a dual diagnosis treatment facility for a minimum of 180 days, determined by and scheduled through defense counsel and agreed upon by the Commonwealth. He's currently incarcerated and shall remain incarcerated until the morning of the bed date. I think we need to wait till his final sentence because sometimes we have trouble locating people once they move, not getting them on Zoom or whatever. Probation shall transport the defendant to the treatment facility.
I don't want Carson to be my probation officer. That's all right. You do? I do not. Okay, well, let's just not, that's not up to you. Okay, right?
Your Honor, in response to what Mr. Stockton said, I say we get him in, go ahead and try to get him in somewhere. And, if he's readily available.
Well, I'm just asking right now if he wants to enter a plea.
Was that what you agreed to, sir?
Yeah.
Yeah, all right. Are you pleading guilty because you did commit the acts charged in the indictment? Isn't it? Okay. Doing so your own free will.
Yeah.
You're under the constitutional rights explained it's still your desire to give up those rights and enter a plea without a court to get your constitution. Correct?
Yeah.
Okay, now do you understand that any of the future convictions be enhanced towards your range penalty on the felony and on the DUI? Get another DUI can be enhanced too. You understand that? Is that your signature on the docket? I'm looking at it.
Yeah.
Document.
Yeah.
Okay, I'll accept the agreement or the pre-sentence investigation for the two-term probation and parole and schedule sentencing for November the 6th. Now, is there anything else?
Your Honor, in regard to Mr. Stockton's request that he be sentenced before he goes somewhere, I would request that we try to place him somewhere that's accessible, remote, where we could do a final sentencing. while he is in his rehab, get his rehab started.
You
He's
can
been,
find someplace and submit it to Mr. Stockton if it's agreeable. I don't necessarily.
As long as I can talk to somebody and they agree to either have him here or have him available.
Yeah, okay, I have no.
Good luck to you. All right. Good.
I'll be working on it, okay?
Okay, that concludes this morning's session. We're waiting the Granger. Got they finished?
They're out just outside.
Good. Bring your you move him out of the way there and bring the grand jury in. I would have a witness with you if I was in there. You need to go in there with me. Yeah.
Yes, sir.
Yeah, very good.
Ranger, you been all right, for the grand jury, we're all up.
Okay, everybody can be seated. Are you the full person of the grand jury?
Yes.
Y'all completed your work?
Yes.
If not, more of you agreed?
Yes.
Okay, you'll give it to the bailiff and I'll examine the documents. Okay, everything appears to be in order here. I'm going to sign the authorizing document with my signature of this order, either
Good afternoon.
Hello. Elizabeth Callen versus Ashley Fairchild.
This is, Your Honor, a motion for contempt. Ashley Fairchild or Elizabeth Cowan out there, have you seen them? They're not there. We request an order for the person to pay $1,200 by November 5th, 2025. Your Honor, we submitted the motion in the order electronically. You filed them correct.
Contempt and purchase of opinion. And what?
$1,200 by November 5th, 2025.
Okay. Stockton versus Cross.
There's an agreed order filed, Your Honor.
Okay. Cabinet versus, that's your,
There's an agreed order filed, Your Honor.
Smith versus Byers Smith.
We've been requested to pass that one. Do you know for how long you want to pass? Generally, or?
They're thinking about maybe getting back together is what we were told by her attorney. And she doesn't want the child support right now. Miss Smith felt. So,
Okay. No, y'all just bring it back up when you need docs at all.
yeah, that's it.
Thank you.
Thank you.
Let's go off the record.
Thank you. Don't work too hard.
Heard here. Mitchell versus Mitchell. Mitchell versus Mitchell. We on here. Do what? She's not on there. Is Ralph gonna appear?
Actually, I would have an idea as to why she's not on, because Ralph's motion was filed in the CI case scheduled at 1:30. Ms. Bonham's motions were filed in the AD cases that are scheduled.
So it'll probably be 2:00. And we'll call it back up at 2:00. Persian versus Menka.
Your Honor, this is Jennifer. She's the mother of the child. We're requesting a supplemental order so that Vital Statistics can comply with the previous order of this court, which basically affects the child's name.
Everybody needs to hold it down. The mics are active over there at the table.
And the court previously ordered this, but Vital Statistics would not recognize it unless the name of the child was spelled out. So that's why we come to court to just supplement the previous order.
Okay, if you electronically submit it,
Yes, you should have it.
okay. Well,
Thank you.
no problem.
When he enters it, I'll get you, I'll be in the thing to Vital Statistics. You may have to file a form now, too.
Another satisfied customer here.
I'm sorry. Thank you.
Taylor versus Bachman. Okay, what we got here?
This is our motion for trial date. We were here previous.
Yeah, the order says it should be placed on October 9th at 1:30 for a trial date unless other motions or objections are filed. What we got going on?
Your Honor, I will be, I've told Gary, as I advised the court, I thought I would do, I'll be withdrawing, but I want to meet with Mr. Taylor and his sister. One of them's in Ohio. So I haven't sat down with them and explained all this to them. Gary wants a trial date. If we're gonna give him one, give it well out, or they can decide if they want to pursue this and let him get away.
Why are you getting out, Mr. Carl?
Because I want to.
I know, but other than that.
I don't need a reason.
Yeah, I know it.
I
I don't
respectfully
have to
say-
grant an order letting you out either.
Well, I respectfully.
So I mean, you don't have to give me a
I sort of
reason, so-
disagree with you. I think if I want to get out, Your Honor, I think I'm entitled to get out.
You
of
don't
this
believe in
case.
involuntary servitude.
No, I don't. And you
You're not
know.
you're not very progressive. I thought you were more progressive than that. Yeah, what's the situation with your clients? You represent,
Gail Bachman,
yeah,
the executrix of the
Yeah.
estate. We just want to get the case resolved so she could administer the estate. Everything's on hold. And so that's why I filed a
well, okay, well,
motion.
why don't you sign an order or submit an order, I'll sign and give them till November 6th to appear here with an attorney or face sanction, and then on that date, they should be ready to set a trial date.
And I will meet with them in the next few days
Okay,
and
that'd be
advise
good.
them of all this, tell them what's going on, and that's fine.
Yeah,
What up-
and it's the problem that I have with this, have you taken any discovery, anything?
Yes.
Yeah, so obviously when they get new counsel, you'll turn that over. I don't know whether,
You haven't taken any
We
deposition.
haven't taken Gail, but you took care of
I
it.
took discovery.
Yes.
You haven't taken it.
No, we haven't taken it.
yeah.
So that
So
would be the only one to take based on what I've seen in the discovery.
what would I put in the order?
Which put order they should appear on that date with counsel prepared to set a trial date? Or in the alternative, file any motions about discovery that they might desire to take?
Send that.
If they don't appear to counsel, is the case get dismissed? As I put that language in there?
That's a little extreme, Harry. But I'll
Well,
give
you're not interested in this case, Mr.
Exactly,
Brown.
are you in or you're
I
out?
think that
I just
you,
wanna
you have
prepare.
lost your ability to kibitz
I
here.
wanna
Wait,
prepare
let's
a
wait just a
soft
second.
landing spot.
I'm not ready to do that. If they do not appear that day and they have not complied. If they do appear and comply, I will move this case forward. If they don't appear, I cannot anticipate that they won't right now. I don't want to, I don't want to. If we come here on that date and they're not here, then we'll do something to resolve your situation.
Are you requesting to sign off on this?
No, he doesn't have to say.
Just to have
withdrawn. He's withdrawn. Oh,
I don't have a written motion to withdraw
Well, why we've been discussing it then?
because I was telling you that I would be getting out. I will be filing.
So you want to keep one foot in, like
No.
the hokey pokey on.
Yeah. No,
Okay, all right, give it to him, let him look at it, and then he'll decide whether he really wants to withdraw or not.
Oh, I'll be getting out.
Okay, okay.
Unless you just put me in stocks and bonds and make me come in.
No, don't tempt me.
Thank you, Judge.
Okay. Owens versus the Medical Center at Clinton County. Mr. Carroll?
Oh, we are rescheduling that motion, Your Honor. There's some actual discovery that needs to be done. And,
Okay. We pass over to be renoticed, correct?
correction.
Okay, that'd be fine.
Thank you.
Yeah. The Medical Center at Bowling versus Journey Pure Bowling Green LLC. Okay, now, you represent,
Journey Pure, we have a motion to withdraw our firm. I'll play with Mr. Green, if you understand that, Judge.
you represent the Medical Center at Clinton County.
Yes, sir.
Who do you represent?
Good afternoon, Your Honor. I'm filling in for April Wimper, representing defendant Journey Pure.
Okay. Now, this is when it went up to Court of Appeals.
It's my understanding.
They sent it back down and said that we needed to have a hearing on damages. They upheld the judgment, but said we need to have a hearing on damages.
Right.
Now, are you prepared to argue the case at all? I mean, or are you just standing in or?
Your Honor, I'm just standing in today to get a date on.
Well, that's kind of rough a little bit because I need some guidance on the parameter, how long anybody thinks this is going to take. How many days, what,
Judge, this is a breach of lease case. I would think my proof would not take more than an hour.
Your Honor, we do believe that the damages issue should be dealt with expeditiously. However, we would respectfully request the court to set a date that's far enough out for us to sufficiently conduct discovery. You did send discovery requests to Mr. English October 2nd. Based on the responses we received for that, we may identify additional witnesses. We're hoping that depositions won't be necessary, but.
do you have any responsibility to cover or anything in this thing? Is that the kind, will that be a cover? Do you have any, like, to try to rent it to somebody else or?
We have tried to.
So you're gonna have, that'll be part of the proof?
Yes, sir.
Your defense to their damages would be that they had some responsibility to cover, is that right, or what?
Correct. Remediation.
Will you have expert witnesses that you're gonna designate as far as damages that have you made disclosure?
We are still in the process of identifying this.
Well, we need to tighten this thing up. How many more days do you need?
Your Honor, we would respectfully request a hearing on damages to be scheduled sometime in February or March 2026. That'll allow us.
Well, I'm talking about how much time do you need before you have to disclose your experts and things like that to them. No, at some juncture, they're gonna have to know who you're gonna call. You told them you're gonna call, have you?
We have interrogatories that they've served on us. We'll have those answered by November 1st.
Yeah.
we will be ready to go after that. It's just a breach of lease. You look at the lease.
That's what you think it is. It's simple, but they might have people they're gonna call that once they give you that list of people they're gonna call, you probably want to talk to them first. So you just want,
Judge,
you'll do it like they used to always do, not worry about that discovery stuff, right?
let's just set it for trial and,
Would it be a retro case where we just let
Yes,
everybody
sir.
come up and say what they?
just sign it
Well,
up,
let's come back on December the 4th. And on December the 4th, let's be ready to set a hearing date. And any kind of discovery problems that either one of you have need to be brought up to me by November 6th, which is our next rule day. So if you got any problems coming up, and really, if on November 6th, you decide both of you are ready for a hearing, I might be able to set you something before the end of the year. If you're ready like that, but we'll just out of abundance of caution. The 6th, if you got any discovery problems, the 4th, we'll set a date, and you don't have to be here. If the only thing we have on the 4th is to set a date, that's just, y'all can get online with us or call our office. Sure. Where the calendar is, and we'll set a date. I think probably ought to set a full day. Just in case. Okay, thank y'all very much.
Judge can have no objection order allowing us out.
Well, you want to electronically file that? Ms. Thompson, do you think y'all let Mr. Carroll do one of this old fashioned way?
Okay, but it's already, you're gonna be on the list.
Oh, okay.
So is it me?
All right.
We try to coddle you and Ted Lappett both. As far as this electronic file.
My office does a pretty good job with it.
I'm not talking about your office, I'm talking about you.
I don't do any of it.
Okay, thank you very much.
Thank you, Judge. That's all I had.
Okay. I'm gonna say this, make this analysis. Before that, yeah. Cabinet for Families and Children versus Harbor. Okay.
I thought.
Yeah, I see here, I, Haley Harbor, am requesting see a judge to get KTAP dropped. Herb Moles, receiver of the money, does not have custody of the children. The KTAP was taken out while I was in jail. The fraud department's called. Okay, the problem is I don't have any jurisdiction over that.
Yeah, well, I went to the child support office and they just led me here.
They what?
They just led me here. They told me to file a petition in court and
Yeah.
see.
Then that, I'm not aware of any authority that I have to direct the KTAP. If you think that there's been a fraudulent payment of KTAP, I'm gonna send you back to the county attorney's office and they can decide whether there's been any criminal activity.
Okay,
You know what I mean? Whether he's fraudulently accepted. I can't
okay,
determine that because the only thing I have is jurisdiction over custody and child support. And KTAP is a program that is handled administratively by a different branch of government, executive branch, okay?
okay, sorry.
No problem.
Thank you very much.
Okay, bye-bye. Collins versus Baldock.
Your Honor, in a great order on that.
Okay, that'll be fine.
They should have sent it to you yesterday evening. Okay. Oh, that's fine.
Okay, thank you. Warner versus Mitchell. Okay, we'll handle that later. That's a confidential case. And the next one, the confidential case also. Okay, is there any other case except for the confidential cases? Okay, well, we will go into recess until the confidential cases come up. And we had that one case maybe that was done. People appeared to, and so we might be on the two. That's both confidential cases. Okay, well, let's go off the record.